debate.
Thank you, Mr. Speaker, members of the House. My friends, in our Idaho Constitution, it talks about judges being elected. Elections are important, and you've seen the last couple of years how people, and in our country, we've had all these concerns, and you've seen bills this year dealing with elections. Elections are important. Through the years, though, we're starting to see more and more of our judges, instead of retiring and filling out their term, retiring early, and the Judicial Council replacing those judges. Now, I understand that's the process we have, and I understand we need that process, but I also have concerns that that process helps establish incumbency. It helps it make it easier for that judge who's picked by somebody else to be elected. I have a concern with that. I do believe, though, that the Judicial Council serves a purpose and that it's necessary, but I also think that we can make some improvements to the Judicial Council. This bill makes some of those improvements. What does it do? It increases the number of people that are on the board. What's wrong with that? More eyes are better. Sometimes when we have less people, and you've seen that in the body here, it's easier to control the outcome. More is always better. When we're selecting those individuals who are going to sit on the board, on the courts and judge over us. It also does the thing that I really like, and it's always concerned me, is that when you go before the board and you try to be a candidate for a judge, you're not given the opportunity to see what others say about you. Sometimes the hard facts of what people think about you makes you a better person. Sitting in this chair, often many of you come to me and say, I think you're doing this wrong. That input can help a person change or become better. This bill establishes that. It gives the judge the opportunity to hear what others, the candidate, the opportunity to hear what others are saying about him. It's a more open process. It makes more of the information public. What's wrong with the public knowing more about these candidates and what they do and who they are? It's not stopping anything from happening. Why do we want to hold back information about these candidates? Think about that. Do we really want to be picking these judges in the dark of night? I don't think so. The more open the process, the better it is. This bill makes it more open. Why would you ever not support a more open process? Do you really think it's wise to pick the members of the third branch of government with less information and with less people and in the dark of night and with less input? I don't think so. This bill does not undo the Judicial Council. This still tries to bring things more broadly, bring more information out, have more input, make it a process that we go through with a vacancy in this body. Let's talk about another thing it does. One of the concerns I've always had with Judicial Council and the fact that they present these candidates to the gentleman on the second floor is he has no say. He gets to choose from a list that he has very little say in getting there. This gives the gentleman on the second floor a little more input on that council. This gives the gentleman on the second floor the ability to say, maybe these candidates in this list, maybe you can do a little bit better job. We had a candidate recently that's never even been in the courts. They're a district judge. Is that what you want? I don't think that's wise. Now, I've heard some people really concerned about the salaries for the judges, and that's been an issue for many years. And in this bill also, we adjust the salaries for judges, and we set it based on the Supreme Court justices, and we work our way down to help alleviate that problem with the spreading out, to help alleviate the problem with our friends in the magistrate courts who sometimes get left behind. Oh, by the way, in this bill, the magistrate courts have a say in the process too. Haven't before. Anyways, Mr. Speaker, this is a good bill. This doesn't hamper anything. It takes a current process we use, it makes it better, it makes it more open, and it makes it more helpful, and it makes it more beneficial to the citizens of the state of Idaho. Remember, the Constitution says they're elected. If we're going to elect them, and we're going to go around that process with the Judicial Council, then we ought to have a process in which those individuals that we all represent have more of a say, and it's more of an open process. With that, Mr. Speaker, I'd like to defer to the good gentleman from 10 to finish the opening comments.
The gentleman yield.
Gentleman yields.
Gentleman yields. You have the floor.
Thank you, Mr. Speaker. The good gentleman from 14 did a great job of going over the high points. I'd like to more or less proactively address some things that you're about to hear. You're about to hear that the citizens' voices are diluted on the commission. That's simply not the truth at all. in order to get a variety of perspectives on this council from the legal field, we did have to add more, because you can't have representatives of opposite sides of a dispute represented in the same person. There's concern that there is a bias built into the two attorney members of the council currently. I don't necessarily share that concern, but I do want to make sure that that perception is addressed, and that if we go about the business of correcting that perceived bias, that we don't instead enable the creation of the opposite bias, just swinging the pendulum from one side to the other. And so what this bill does is it has parity. So we did add 2 attorney members and 1 at-large member, but we also, if you look at the bill, require that 8 members of the council agree in order for anything to happen. 8. And so we have not in any way diminished the public members' input. You're going to hear that this is court packing, which is a bit ironic considering what we've heard about court packing from the national parties in the last few years. But, Mr. Speaker, if we were going out to dinner and you said, where do you want to go? I said, I don't know, give me 3 options. And then I picked from your 3 options. How much say did I really have in where we went to dinner? The fact that our legislative seats and our county-wide seats are subject to a list of 3 to the governor doesn't mean that when a member of the minority party vacates a seat, that the governor, if the gentleman on the second floor happens to be of the Republican Party, as he has been since 1994, that he can then choose to pack that seat with a Republican or a Libertarian or a Constitutionalist or an Independent. No. The Central Committees offer 3 names. The governor just has the ability, and I refer to the governor generally as the office, not the specific gentleman on the second floor. The governor has the ability to pick among the 3 and to vet those persons, but the governor has to stand by that choice. And then the governor has to stand for election before the body. As the good gentleman from 14 said, we are putting the purple robe of incumbency on the black robe judges through persons appointed to this council who are appointed by persons who will never face any electorate. And by our Constitution, these positions are elected positions. You'll also hear about a letter from 5 retired Supreme Court Chief Justices, and I respect their commentary and I appreciate them reaching out to me. But one of those 5 Chief Justices has been somewhat critical of the ongoing practice within the judiciary to avoid elections in general by almost universally resigning or retiring before the end of term instead of allowing things to go to an open election. Retired Chief Justice Jim Jones acknowledged in the past he would have never been on the court.
Mr. Speaker,
Gentleman from
point of order. This goes beyond the scope of the bill. This bill isn't about judicial elections, so I'm not even sure how the debate got onto judicial elections. It's way beyond the scope of the subject matter of the bill.
Mr. Speaker, I will connect the dots.
Connect the dots. I tend to agree with the gentleman from 29, though.
So where is the intersection here between judicial elections and this bill? One of the 2 functions of the Judicial Council is to appoint openings. Is to appoint a judge to fill a vacancy at the district court, the appellate court, and the Supreme Court level. Those are elected positions, and they are being appointed to fill an elected position without standing election. And if that dot isn't closely enough connected, allow me to connect another one. That the opposition to change is to leave alone and leave further removed from anybody who stands responsible to the electorate to choose the people who are serving without being elected. Currently, the 2 attorney members are selected by the bar, subject to confirmation by the Senate, but just by the bar. I respect the Idaho State Bar. I appreciate the current commissioners and the past commissioners. But none of those commissioners face the people of Idaho in an election. They no accountability for their choice and who goes on this council. And the difference is, by simply asking those same people to send 3 options to the governor, we are not taking their ability to appoint away. We're not taking their independence away. We're giving the final responsibility to somebody who has to stand election. So the alternative to the Judicial Council is an open election for an open seat. So why doesn't that happen? It is because there is a tradition among the judges to create these openings, which is precisely why the Judicial Council is so important. And Chief Justice Jim Jones stated he would not have ever made it onto the court had he not had the opportunity to run for an open seat on the Idaho Supreme Court. So had this tradition in the judiciary of avoiding elections by retiring so your replacement could be appointed by this Judicial Council instead of by the voters of your county or of the state of Idaho, had that carried on in that seat, one of the 5 Chief Justices that are criticizing this bill would have never had that opportunity. So the connection of the dot is that this is about placing in front of the people the ultimate responsibility for holding these selections accountable. And that's the only purpose. It does not give the governor the ability to choose the attorney members. It just simply requires that they submit 3 names and that somebody who is accountable to the electorate has that final say among the 3. And I don't think it's too much to say that we all have seen situations where, at least informally, we think that a submission of 3 to the governor was packed, either by a central committee or some situation that in our own opinion we thought was chock full of options that perhaps the gentleman on the second floor wouldn't appreciate. And I have no doubt if there really is a desire to send somebody of a particular point of view that the bar can figure that game out too. You're also going to hear, Mr. Speaker, that we need to take our time and get more feedback from the judiciary. And frankly, I was slow to engage with this legislation. I was slow to push on this legislation. But I see its need. And the package before you is a well-articulated, well-balanced approach to that doesn't allow the solution to one issue to give way to the solution to another. After Mr. Speaker, I'd ask unanimous consent to refer to House Bill 600 and Senate Bill 1382.
You've heard the request. Is there objection? Hearing none. Gentlemen may refer to those aforementioned bills.
Thank you, Mr. Speaker. So one of the criticisms of this bill is it's being rammed through at the last minute here. House Bill 600 was introduced on February the 11th. And before that, it was introduced, the RS was presented to the Chief Justice of the Supreme Court. Senate Bill 1382 was introduced on the 7th of March, much later, but after a lot of conversation. So it's not as though we hid this somewhere in a drawer in the back room. We did not hide this from anybody. This has been a conversation that's been going on. In fact, the good senator from 9 repeatedly asked the courts for feedback. And it's true that after being presented with the RS on House Bill 600, the court proposed an interim committee of their own and invited us to participate. But in trying to negotiate legislation with them, they would not come out and engage. They would only offer to delay. So they have both come to us and said we should have more input from them, and then also come to us and said that we will only get their input if we engage with them on their terms, on their timeline. And ladies and gentlemen, I find that to be unacceptable in trying to interact with a coordinate branch of government. This is a good, well thought out, well balanced piece of legislation. It keeps various areas of the bar engaged. It keeps members at large engaged. It does move accountability to somebody who has to face the electorate without completely giving that person unfettered power. In Montana, things went so awry with their judicial council that they completely eliminated it, and the governor of that state is permitted to just pick attorneys off the street, for that matter, and appoint them. And I don't believe that that's where we should go either. But we need to adopt this language. Thank you.
Is there further debate, Gentleman from 30?
Thank you, Mr. Speaker, and ladies and gentlemen. I rise to debate against the bill. This bill does not fix the problems that it claims to fix. That's the bottom line. No one has ever shown to me that the Judicial Council, as it presently is constituted, has ever caused any problems. If there's any reason for this bill, it must be political. Someone fears that our judges are too liberal or something, but I don't know any Idaho judges that I would consider that way. It is true that our judges resign early and get appointed and establish some incumbency. This will never fix that problem. Out of the 40 judges listed in the filings for election, only 3 out of 40, only 3 will have any opposition in May. If we want to fix the process, then let's fix the process. Let's talk about how we fix this entire process of choosing judges in the state of Idaho. This bill doesn't address any of that. For instance, the gentleman on the second floor has the right to choose those who are on the council, and the Senate has the right to confirm those on the council, but the Senate has no right to confirm the judges who are appointed. There are bigger issues here that need to be addressed, and this bill doesn't address them. There are a couple of things in the bill that for me are just red stop issues. One of them is on page 3, subsection 4. You're probably aware that when a judicial candidate is identified, other attorneys are asked to confidentially rate the qualifications, experience, and capability of that candidate. This provides feedback from the bar on the candidate's competence, fairness, and judicial temperament. Lawyers provide this feedback because they do it knowing that their responses will not come back to haunt them, that they can be honest and forthright. In this bill, these reports, these recommendations will be made public. The chilling effect that this will have on honesty and fairness in rating those who will become our judges is simply unacceptable to me. I believe the chilling effect will be very cold. There are several other issues here. I don't think it's right for us to put the raise for the judges in this same bill. I'm not sure that changing to a percentage is the right thing to do. If you change to a percentage for raising the salaries, then over time you simply broaden the distance between the Supreme Court judges and the magistrates. I'm not sure that it's a good idea that only 5% salary separates our magistrates and our district judges. We are having a very difficult time finding people who are willing to be district judges. There are many, many other things I expect others to debate. I simply want to let you know that I feel this bill does not solve the problems. The Judicial Council seems to work well now. This bill has in it some very, very disturbing things that I don't think we should go there right now. So I ask for your no vote.
Is there further debate? Good lady from District 18.
Thank you, Mr. Speaker, to debate against the
You have
bill.
the floor.
Thank you. First, I want to start out, notwithstanding the comments of the good gentleman from District 10, I have very serious procedural and timing concerns about this bill. We're talking about a system that has worked superbly well for 55 years, and we're talking about completely turning it upside down and inside out, and frankly, highly politicizing a system that thus far has been nonpartisan and pretty non-political. And to do something so profound, I think it's very inappropriate to do it in less than 48 hours, nearly a month past the deadline for introducing new legislation. I think maybe 2 weeks after the transmittal deadline. It's been less than 48 hours since we've even seen the language in this bill. I have attorneys contacting me from all over the state saying, you know, what's going on? I hear they're doing something to Judicial Council. I haven't seen the bill. I haven't heard anything about it. What? Help, I'm out of town on a deposition. How do I stop this? This is not how to do serious big business like this. This is a big issue that frankly does deserve the kind of broad-based participation that the Chief Justice of the Supreme Court has proposed. As many of you know, they've proposed an interim committee with participation from all three branches of government to take on something this fundamental. This is not something that should be, ripping through like greased lightning in under 48 hours. So on that basis alone, I think this bears more thought before we even get into the substance of this bill. This is a terrible way to do business on something this important. But beyond that, I really do have pretty serious concerns, and I very much underscore what the good gentleman from District 30 said. I've served on many boards. I have never served on a board that didn't go into executive session to discuss personnel matters. I think that's a fundamental principle. When you're having these delicate conversations where you need people to be able to be honest and candid and put out everything that they know without it coming back to haunt them, it's vitally important that you do that in a more private setting. Idaho is a pretty small town where everybody in the legal community knows each other pretty well, and if you're going to put a rule in here that everything that's said has to be public, you are not going to get vital information and vital feedback on these roles. And people are going to be making decisions with far less than the full information that they need. And this, I'm sure many of you have been on boards, and I'm sure many of you have had this experience, and I'm sure every single one of you that's been on a board has gone into executive session to discuss personnel matters so that you can be candid and honest and get all the information you need out on the table. Beyond that, I don't know that this is really an improvement in transparency. It's an enormous shift of power to the executive branch. And we're not going to have a lot of transparency in the decisions being made there. We're not going to know what super secret considerations are going into the governor's considerations on how he picks this or that person. And that's where all the real decision making is going to happen. And we will have absolutely no transparency into that process. So I think it diminishes the quality of information we're getting, but doesn't really meaningfully improve any transparency at all. And I just think, I don't like this shift of power. I think we're looking at a separation of powers question. The folks who are going to be in the judicial branch are by definition going to be making decisions on the legality of actions taken by the executive branch. And shifting all power, or at least a humongous amount of the power, into the hands of the person who is to be judged by these people, I think is just unwise and runs afoul of all of the principles of separation of powers that make this country and this state great. So with that, I hope you will give this your red light and give us time to think this through in a more reasoned and balanced fashion rather than ripping it through in the final hours of session. Thank you.
Is there further debate? Gentleman from 34.
Thank you, Mr. Speaker. William Shakespeare said, "Misery makes for strange bedfellows," but it's been adapted to "Politics makes for strange bedfellows." And I can't tell you how strange it is, the lobbying I've received from quite a combination of different groups and different individuals. It's really surprising. I've never seen anything like it before. But makes me wonder what's going on with this. I'm going to offer maybe a different perspective. I served on the Idaho Judicial Council for 6 years. And my experience on the Judicial Council was amazing to me. I worked with some very professional individuals, including the 2 Chief Justices of the Supreme Court, Dan Eisman and Honorable Dan Eisman and Honorable Chief Justice Berch. I served with attorneys on the Judicial Council, Bill Parsons from Burley. I served with Ann Solomon from up north. I served with great District Judge Ron Wilper. There are also non-attorney members of the Judicial Council as it's currently constructed, and that's how I ended up on it. I am not a legal professional nor an attorney, but I served on there with Phil Rieberger and Sherry Krulitz from up north. Just a stellar group of individuals. In fact, I felt out of place a lot of times. The Judicial Council has two main functions. One is when there's a vacancy in a district judge, an appellate judge, or a Supreme Court judge, and then the Judicial Council puts out the call for applicants, reviews the applications, gets commentary from Bar Association members on the candidates, interviews the candidates, and reviews the commentary, reviews the survey that they take in judging the candidates, and then goes into executive session and discusses whom they think the best candidates are. The law says that the Judicial Council has to submit a list of minimum of 2 up to 4 individuals to the governor for appointment. And that process was amazing to me. Also, it should be noted in current statutes that no greater than 3 members of the Judicial Council can come from any political party. So it is constructed to be apolitical, and it actually functioned that way very well for me. I noticed that politics never came into play. It was always about who is the best candidate for judge. Who can we put on this list to be the next judge in that position? We reviewed their applications in detail. Their applications, by the way, are about 20 to 25 pages long. And the bar review, the commentary from colleagues who are reviewing how those attorneys or judges or legal professionals worked was very telling. Many times there was consensus. Sometimes there was consensus all except for a couple of outliers who had some really negative things to say. Sometimes it was very clear that there were problems with the candidate. That commentary, that candid commentary, was very important for determining how this person fits in the legal environment and how they would conduct themselves as a judge. Temperament of judges is a very important consideration when you're appointing judges. I think the Judicial Council worked very well. We got the best candidates, sent them on to the governor, and in my opinion, the governor didn't always pick the best one of that list, but the governor had a choice, for sure. But he had a choice of 2 to 4 stellar candidates from those who applied. The composition of the Judicial Council right now is 7 members, including the Supreme Court Justice, a district judge, 2 attorneys, and then 3 non-attorney citizens. This bill proposes to change that to 11, so we're expanding the council by 4 positions, adding 1 more non-attorney member, adding a magistrate judge, and bringing it up to 4 attorneys, then the district judge, and then the Supreme Court judge. Supreme Court Chief Justice. That composition does change the balance of power because the governor will be appointing 8 of those members. Right now, the governor only appoints 3 of 7 members. Then it will be the governor making the choice on 8 of 11. It is a shift in power on what the governor chooses. And while you may like the governor that you have now or prospects for the future governor, there's no guarantee that the governor is, we shouldn't be making decisions on who sits in the chair now because we're making decisions for Idaho's future. And that position changes quite often. The disclosure part of this, like I mentioned in the application process, getting commentary from colleagues is very telling. This bill says that the summary of those comments and the ratings of the Judicial Council will be made public, but it also says that the comments made in the bar survey will be provided to the candidates upon their request, and the candidates will not only see the comments, they will see the source of those comments. This is the most disturbing part, I think, of the bill for me, because it will have a chilling effect on the comments that are received through the application process. If there's a candidate for a judicial nomination and I'm an attorney, I want to be very candid in my comments. If I think that person is not suitable for a judgeship, based on my experience, whatever they've done to offend me or show their incompetence or show their lack of respect, whatever it is that I might want to say, if I know that that candidate will see the comment and see that I made that comment and still may be appointed nonetheless, do I as an attorney want to be candid when I may be standing before that judge with a case? When I may still work with that person as a colleague should they not get appointed? It is going to have a chilling effect on the commentary, and it will provide less information to the Judicial Council, who are making very important decisions on who to put on that list. And that is a disturbing part of this bill. If we could take that out of the bill, it would improve it greatly. Like the good lady from 18 said, going into executive session is very important. All sorts of decisions made across the state. We have school boards, choosing superintendents, everything. They go into executive session because you need to have candid conversations. When you have candid conversations about people, about candidates for things, they deserve a certain extent of privacy there so that they can speak freely and make the best decisions. Executive sessions have a purpose. The information from those sessions also serve a purpose. And if it is required to tell all the information from those sessions, you're going to have less candid commentary. The Judicial Council, as it's structured, may not be exactly perfect, but it is not this broken. To drastically change it by adding this many members and changing the composition of it, also in this is composition of civil versus criminal attorneys and prosecutorial versus defense attorneys. Those changes, those are challengeable. Somebody will say, well, that's not really a civil attorney, yet they got appointed or they got put on the list. We're going to have challenges about whether attorneys are civil attorneys, criminal attorneys, prosecutors, or defense attorneys predominantly, because that's the word used in the legislation, is predominantly. Are we going to now have to have all sorts of challenges on every nominee based on that? This is a huge shift in power in the conduct of the Judicial Council, going from 7 to 11. I say is more bureaucratic. This is adding more more bureaucrats, more decision-making to this. There's going to be an increase in cost from it. And I argue this is not the change we need. If you think the governor is not getting the right amount of power he needs, I know the U.S. Judicial appointment process works very differently. The president chooses a nominee and the Senate confirms. If that's what you want, if that's kind of power you want for the governorship, then that's what we should propose. We should dissolve the Judicial Council if that's the choice here. We shouldn't expand it. This goes in the opposite direction if that's your goal. So this is, I say it's trying to fix a system that is not broken. My experience on it was we got the best, most amazing candidates on that list. That interview process, we have such a great great assembly of attorneys and judges in this state. And sitting in those interviews was truly humbling to see the professionalism and the excellence that we have across this state in the judiciary. We have great candidates to choose from, and I think the Judicial Council does a great job at doing that. I don't think we need to fix a well-functioning system. We certainly don't need a reform like this that could lead to bigger and and worse problems in the future. So I'm a no on this, and I encourage you to vote no, and maybe we could consider this again next year and find some more reasonable ways to do this. I understand the concerns, but I also think that this bill isn't doing what is needed to be done.
Is there further debate? Lady from 6.
Thank you, Mr. Speaker, to debate the bill. Thank you. So, most of you know, my career has been in the legal field for almost 45 years. And I will declare a real lady while I'm up, because my husband is a lawyer, and I taught the paralegal program at LCSC for 16 years.
Your declaration will be noted in the journal. You have the
Thank
floor
you.
to debate.
So this bill is a bit troubling, and I'd like to just start with a couple of things that were said early on. And number one, the decisions aren't made in the dark of night. The decisions are made collaboratively with a judicial council that has been established since 1967. This has worked very well, and to just throw it out the window without a collaborative discussion is troubling to me. The good gentleman from 10 said that it has been out in the open and it's been there since February. However, if we look at the actual situation here with the bill, it started on the other side of the rotunda on March 7th. It was sent out of the committee to general orders, and now we have it here on March 15th, and we are at the 18th. So there has not been a lot of open, collaborative workings, and that really does bother me. So then I would like to talk about some of the changes in this bill. One of them that I really don't like is the fact that a general practitioner would be precluded from ever sitting on the Judicial Council. My husband, who's practiced over 50 years, is a general practitioner. He goes to court. He is in front of judges, and I was asked the question, well, why would general practitioners who are not trial lawyers, why should they get to pick judges? And it's like, well, we need to understand, even though you are a general practitioner and you might do real estate law, you might do corporate law, you might do domestic relations, you are going to be in front of the court. And so when this process comes to play, the Judicial Council does not choose the judge. We need to make sure we understand that, because the good gentleman from 10 may have just misspoke, but there was a little intent there, or it sounded that he said to me that the Judicial Council is making these decisions, whereas they are giving a group of people and potential judges to the governor, who makes the final decision. So, but if we are going to change this entire process, because we believe maybe we need to elect judges, or we believe the process is flawed, then I'm okay with, let's sit down as a group and be collaborative. But I don't think that we should make a rush decision, because this is huge. We have 3 branches of government, and this is one that is very, very important to all of us. And without the 3, we don't have a balanced government. And so I've talked with stakeholders and attorneys. I've had more interaction on this bill than I have on any other bill this whole entire session. And so when I talked with members of the State Bar, or from the State Bar Association, or from the Idaho Trial Lawyers Association, and they said, we've had no input on this. We've not had an opportunity to weigh in. That's not right. So I would ask that you all give this some real deep consideration before we put a green light on changing this process, because this is a big deal. This isn't just a small bill that we can say, you know, by a wave of a hand, let's change the process, because we do need to be thoughtful. So is it perfect? Oh, I would say no, absolutely not. But it's worked for an awful long time, folks, 1967. And so to just say, hey, let's throw it out with the bathwater is, in my opinion, not prudent. Then lastly on this, and it has been talked about, but I want to just share with you that since I've worked in this field so long, and I've worked with great attorneys, lousy attorneys, great judges, lousy judges. It's just like any field. So, but this process is not totally broken. There might be some flaws. But when we are going to take these surveys that the attorneys fill out, and honestly, we would sit down as an office staff and we would talk about, what do you think about this particular person that is looking at being a judge? And we all had input. And the attorneys have to sign their name to this, and then there is a summary that goes to the particular candidate that they do get to see what is said against them, or in positive. But they don't see right now the names of the attorney who sent in the information. And as others have said today, if that happens, it is going to change how we get our judges, and not in a positive manner, because you're going to have a lot of attorneys that are going to hold back and not give their honest, open opinion. And so those are just some of the issues. So I know there will be some other things talked about today, and I don't want to stand here a long time, because this has been a long debate. But honestly, folks, this is a very important vote for us, because it can really change a third branch of our government. And I really think we need to think about that before we make a change. I would like to see us go back and sit down with all the constituencies and stakeholders at the table and negotiate what we think should work, because that's a collaborative way. That's the Idaho way. That's how we do things. So I would ask for your red light on this. Thank you.
Thank you. Gentleman from 16.
Thank you, Mr. Speaker. Would the good gentleman from 10 yield to a question?
Will gentleman yield?
Gentleman yields.
Thank you, Mr. Speaker. Good gentleman. Yesterday in committee, one change that was not brought up in conversation was the change from the term of members of the council from 6 years to 4 years. Could you explain to me the policy consideration for changing the terms from 6 years to 4 years for members of the Judicial Council?
Gentleman from 10.
Yes, thank you, Mr. Speaker. Good gentleman. The rationale is that if what we are after here is accountability via somebody who has accountability to the electorate, that more frequent reviews of those appointments are in the public's best interest.
Gentleman from 16.
Or follow-up, Mr. Speaker?
The gentleman yield.
Gentleman yields.
Gentleman yield.
Thank you, Mr. Speaker. Good gentleman. We currently have 6-year terms for things like the Public Utilities Commission and the Tax Commission. Do you think that the Judicial Council should have more or less independence from the executive branch than those other commissions?
Go from 10.
Mr. Speaker, good gentleman, I think it's a false dichotomy that's been asked in the question. I think that absolutely the judiciary should have superior separation as a co-equal branch with the executive branch. However, does not make the judiciary reliant on the executive branch simply by shortening the term, as the source of all of these appointments continues to reside outside of the executive branch, except for the public members, where the Supreme Court would appoint the judicial members. Right now that's the bar, and the bar would still present those who would be appointed as attorney non-judicial members.
No, 16. Is there further debate? Gentleman from 29.
Thank you, Mr. Speaker. My biggest concern with this bill is that it harms the independence of the judiciary. And I know we've been debating a while on this. I know everybody's getting a little tired, but as the good lady from District 6 mentioned, we are talking about launching on a path that could seriously harm another branch of government, one of the three branches. This is not something that should be taken lightly. I'm launching into this debate assuming that we are all on the same ground when it comes to the importance of the independence of the judiciary. I know we learn it in civics lessons. I know we talk about it. It's something that I think we all just assume everybody believes in and values. But I want to make sure that we really understand the importance of it. I wouldn't want to overlook that. It's important for a reason. It's been recognized by our founders as an essential building block in a strong democracy to have an independent judicial branch that protected the rights of people, was not subject to undue pressure from outside sources, could make unpopular decisions, really. One way of looking at it, frankly, is that we have independence in our judicial branch because they need to protect us from ourselves, both as citizens, but also protect us from ourselves in this body. And here's what I mean by that. In doing this job, and I'm not criticizing us for this because it's just part of the job and the way it works, but sometimes we act quickly. Sometimes we act out of passion. Sometimes there's a particular group that's important to us, or the events of the day cause a particular group to be in the forefront, and so we act rashly. We do that. We all know that. Sometimes legislation is thrown together and the language is a little sloppy, but we overlook it because we think, we got so much other work to do, and so we go ahead and vote yes, even though we know at some point that language is going to trip somebody up and create problems. We do these things. Public opinion can cause us to act, but we kind of have the ability to do that because in the back of all of our minds, we're thinking, well, that's right. There's some justices over there that are going to take a look at this, or there is a district judge that will take a look at this if it's a real problem, and they'll stop it. We know that's their job. We know that's why they are in this process. They're one of the three branches. They make sure that in doing our job, we don't take advantage of a minority group, that we know that we will be able to go to court if that ever happens to us, and we'll be treated fairly. The rule of law will prevail. The independence of the judiciary is essential. I mean, imagine if you had worked your whole life with your spouse to build a business, and you've done a good job. In fact, you did such a good job that a bigger business decided you were a threat to them. And so they took you to court to shut you down, to harm your ability to make money, to employ your employees, to do all the good things you were going to do with this business. And imagine if, unbeknownst to you, that bigger business had an in with the governor's office. And that governor had made sure he had certain people appointed to the bench that were going to be adverse to you because they were linked heavily with this business. I mean, you can imagine 100 different scenarios of how having a judiciary that's not independent can create problems for you and your family. It's essential we have an independent judiciary. So this is where I'm getting to. This bill shifts heavily the influence of the governor's office in being able to control who gets on that bench. There were some remarks about the Judicial Council acting in the dark of night, that the process was the dark of night. That has just never been my experience from talking to people who've served on that judicial council, and the good gentleman from District 34 confirmed that. It's a very open process, good discussions with lots of voices contributing. Here is the dark of night scenario that I worry about. So this bill, right now, the governor's office only chooses 43% of the members of the judicial council. Under this bill, that increases to 73%. The governor chooses 73% of the people who will serve on that judicial council. Under the present system, you would have to have influence with both the governor's office and the Idaho State Bar and the Supreme Court in order to ensure you could get what you wanted out of the judicial council. But here, where the governor can appoint 73% of the members of that group, if you want to, in the dark of night, go to influence one individual or entity to get what you want on the judicial council and thereby have a better chance of getting what you want in judicial positions, you've only got one stop to make in the dark of night. In other words, the dark of night argument, we are more vulnerable to that under this legislation than under the current system. There was an example used about picking a dinner spot. I don't know about you, but when I'm in somebody else's town and they say, where do you want to go to dinner? I'm happy to have somebody narrow the choices. I love that. You ask me where I want to go to dinner, I am stuck in indecision because I want it all, especially if I'm hungry. What I need is for somebody to narrow it. All right, without connecting a dot that doesn't need to be, or I hope it doesn't need to be connected. It works the same way. Over time, in our industries, we develop a bit of expertise. And yes, it is kind of offensive when people come in and say, yeah, I know nothing about your industry, but let me tell you how we're going to do this. This system that we currently have, the reason it works so well is because it allows the Idaho State Bar to have a say in it. They don't dictate what goes on. They just have a say in who is on the judicial council, and they've offered up good people on that council. All right. One of my other concerns is that this bill increases the number of attorneys on the judicial council. I know that's going to sound funny coming from an attorney, but I've served in a number of different groups, including this body. My law partner served on the magistrate commission in our local district. And on the magistrate commission, for example, if you've ever served on one or you're aware of them, there are a lot of non-attorneys in that body. And they're there to pick judges, magistrate judges. And he's had the same experience I've had, which is that sometimes when you get too many attorneys, we don't make good decisions. We're not risk takers as a general rule. We get caught up in details that sometimes stop the process or, making good decisions. So, I mean, we do make good decisions. I don't want anybody to think going to an attorney will result in a bad decision, but I think you've all dealt with this here. You know the deal. You know what we can do when we get together and start speaking attorney talk. This will take the number of non-attorneys from 43% to 36% on the judicial council. It'll take the attorneys and judges from 57% to 64%. I'm telling you, you put that many attorneys, judges in a committee, a deliberative body, they are going to dominate that. And the voices of the people who are pretty common sense when they come in and contribute will be diluted. I just want to touch on one of the other issues that was brought up was the comments, concern that these comments that are made in this process, this new bill would expose those comments to the public and to the individual being reviewed. I get it. Some people may just feel like, yeah, just let sunshine cover all those comments. But I just would ask that you kind of take a step back and think about what's really happening here. So most of the time when you're commenting on somebody who's up for judgeship, you're commenting on somebody who may sit on your cases. And so just by commenting, you're taking kind of a risk, because if they get appointed and you had something negative to say, you worry that it's going to impact your clients, it's going to impact your livelihood. And so you know what sort of things we judge our fellow bar members as they apply. It's things like timeliness. If you work with this individual, are they pretty timely in getting their work done? Do they have good communication skills? How are their writing skills? Have you been in court with them? If so, how they do. Judicial temperament is a big one. It's kind of an intangible judicial temperament. I don't necessarily have it. I can get pretty ticked off, but that's not who we want on the bench. In fact, it's a pretty particular personality that is good at being a judge. It is an isolating job. Once they go on the bench, even some of my good friends are now judges, but I don't communicate with them. I don't talk to them very much, occasionally, but it's because I don't want anybody to have a perception that I've got some special relationship with them and I'm going to get special treatment. I don't want that perception. I think most attorneys feel the same way. And so we, whether it's consciously or subconsciously, we stop communicating with them. It's a pretty particular personality that would choose to be a judge, and that sort of personality usually isn't the type that wants to run for office. People who want to run for office are like us, somewhat gregarious. We like to work with people. Judges tend to be academic. They would love nothing more than to have books and a computer and write decisions. It's weird, but there are people who like doing that. Look, I know there's a complaint about, or a suggestion that other entities were trying to delay this process. One person's delay is another person's thoughtful consideration. And as I talk to attorneys from different groups, all kinds of practice areas, what I'm hearing is, this is not broken. Why are we doing this? This works. And they are very, very worried about this, because this makes all the difference in how their clients are treated, whether their clients are treated fairly. I hope we will take this decision very seriously as we get ready to vote. It could be the most important vote we make this session. Thank you.
Thank you, Mr. Speaker. I rise to debate against this bill, and sometimes I feel like that's kind of a sticky wicket with my good friend, the chairman of my committee. And I did used to work for the Supreme Court. I don't believe that requires a Rule 80. It's been 6 years, but it's a good bunch of people. And when I hear good old boy system, as this good old girl said, that's offending to me. I don't think it's a good old boy system, and there's many women that have sat on and presently sit on the Judicial Council. And I look around, and how many of you were appointed to this position before you were elected? Quite a few of you. I can look at several of you that were appointed. Then you stand for election. The judges do exactly that. They're appointed, and then they all stand for election, with the exception of magistrates who stand for retention election. If we're going to make any change, maybe we need to make the change that DJs and on up stand for retention election. But they do stand, and so when I hear they don't stand for election, it kind of makes my blood boil. I kind of liken the Judicial Council to the Magistrate Commission, which I have facilitated probably 100 in the last 25 years. And the good gentleman who just spoke, I don't see his number on there, is right. Actually, the more people we have from the public on there, it works. I used to scratch my head and say, how can this possibly work? These people don't even know about the system. But they read everything that comes to them. They read all those comments. They read, everything that comes, the criminal reports, the tax reports, they have everything. And let me tell you what happens if a judge knows who sent that stuff to them. Well, it becomes my problem as a court administrator, because then they must recuse themselves on all of those cases of that attorney. And if they don't, then there's a serious problem that they'll probably end up in the Judicial Council. So you see, they have lots of checks and balances here that we have not always thought about. And, just to think about the names that the Judicial Council sends to the governor, it's not like when your county commissioners send the names of the people they want to replace to him. They usually say, this is who we like first, second, and third. The Judicial Council cannot do that. They send A, B, C, and D. They do it in alphabetical order. And so the governor then gets to do his selection. And you've all been called, or I've been called before, what do you think of this person that's running by the governor's office? They do their checks, and they do get information that they need on these fine candidates that come before them. Yesterday it was mentioned that our magistrates are treated miserably. Well, I'm here to tell you they really aren't treated miserably. Our magistrates are a good bunch of workers, and I, kind of funnily say they're our MASH unit in the court system, because they deal with all of the emergency things and they get it done. And over the years, their salaries have all increased. And about 5 or 6 years ago, we got the compression to where it was finally stopped, and there was enough difference between a magistrate and a district judge that a magistrate really wanted to apply for that district position, because it gave him a little step up in salary. However, now, if that starts lessening down, the magistrates, why would they want to do that? Because they go in and their responsibilities are so much stronger when they become a district judge. And I say this, I've worked with so many people that have been magistrate judges, then they've risen to district judges, Supreme Court justices, and chief justices. And many of them have come from my district. So there is a pattern here, and don't ever think that the magistrates are not looked at seriously when they go before the Judicial Council. It just is not so, unless maybe they've had a lot of things go wrong in their magistrate life. Let's see if I have something else down here that I don't want to make this any longer than it needs to be, but I think our system's working. It's worked fine. If we need to make changes, let's get together and make changes. I applaud the people that are working on it. I just personally do not feel that we're at this crisis that we must change the standards that we have for our third branch of government. With that, I would ask for your red light. Thank you.
Mr. Speaker, I think I'm not going to disparage anyone that's ever been appointed to a judgeship, but I do think our process needs a little bit of work. I'll give you a couple examples. I've written a number of letters for lawyers trying to go into either magistrate or district judges. And in one case, at least, they got one of the positions, and the others, they did not. And I've also talked to other people who have been observing this. But right now, if you don't get nominated, you don't know what happened. You don't have good information on what can you work on. These guys are usually in their 30s or early 40s. What do you need to do different? What are some areas of weaknesses that you can shore up? Also, you're wondering, man, did I not know the right people? Did somebody know the right? You just wonder about that. So this bill cleans up two of those problems. One, there's transparency. So the report that gets sent to the governor is a report summarizing all of the factors that were considered. Comments, ratings, whatever was considered, and so that these people who, if they don't get the job, they can say, okay, I'm going to go work on this, and this, and try again. Because quite often, a young lawyer, and he's 35 or so, will try again when he's 37, try again when he's 39, try again when he's 42. Right now, they don't get good information back, and I think that's a serious flaw with the present system. The other one is, if you're wondering, well, because you don't know what happens. You don't know who knew who. But if there's another step in there a very transparent process where it has to go to an elected official, I think this will give people confidence and it will increase our pool of highly qualified candidates. So I think this is not a wholesale change. I think the basic process is the same, but who is making this election is modified slightly, and the process is more transparent and clean. And I think we need to make these few changes, and so I'd urge the green light.
Gentleman from 32.
Hey, Mr. Speaker, I call the question.
Oh, did the gentleman move the previous question?
Move the previous question, yes, Speaker.
Gentleman from 33 for the second. This is non-debatable, requires 2/3 of the members present for passage. Clerk will unlock the machine and the members will record their votes. Has every member voted? Burns, Gannon, are there members who wish to change their vote? Clerk will lock the machine and record the vote. Vote count shows 19 in favor with 44 against and 7 absent. The motion has failed. Is there further debate? Gentleman from 16.
Thank you, Mr. Speaker. I have a political secret to share with you all. Contrary to all the rumors I've started, I am not a native Idahoan. I am actually from Indiana, and the first time I moved to Idaho was when I was 19 as a missionary for the Church of Jesus Christ of Latter-day Saints to serve in the thriving metropolis of Preston, Idaho. I didn't think I'd come back, and I did. And the reason I came back was to go to law school. I got a scholarship here, and we've made this lovely place our home. One of the primary reasons that I did that was in law school, I came to know a very small bar and a very friendly, competent, and independent bench. Many of the judges that served throughout the Treasure Valley taught me in law school, and I have always been impressed with their work. I've always been impressed with their demeanor, and I continually am impressed with what they do when I appear before them as attorney today. It's difficult for me to overstate the significance of what we're doing today. The Judicial Council has been in its current form since 1967. While we're not amending the Constitution here, this has probably deeper ramifications than most constitutional amendments that we do. This bill probably represents the greatest increase in gubernatorial authority over another branch of government that I will probably ever vote on. That bothers me because I know that an independent judiciary is critical to maintain the rule of law and a free and democratic society. And this frightens me. I also want to talk about the fact that we have moved from 6-year terms to 4-year terms. Like I mentioned earlier in my questions, the Public Utilities Commission, the Tax Commission, those are on 6-year terms. And the reason for that is twofold: independence and continuity. Those are things that we want on the Judicial Council, and that's why we have those provisions for those other councils, and I want them here. I want an independent judiciary and an independent Judicial Council so that when we elect a new governor, he or she, every 4 years, that the Judicial Council is not going to move to and fro on the political whims of whoever came into office. Additionally, I'm very concerned about tying salaries inside this bill. bill were to be challenged on the single subject rule, who gets to review that decision? The Supreme Court. And they get to decide the constitutional question if it was appropriate that we paired two pieces of legislation together like this. I think that's a political and a legal mistake. Additionally, when we are paying magistrate judges 85% of what we're paying Supreme Court judges, that creates an incentive issue that compounds an existing issue we have where magistrates don't want to be district judges. Why would I do twice as much work and run for a contested election for just 5% more in pay? It's exacerbating an existing issue. I am voting no today because I am not comfortable giving the gentleman on the second floor or the good lady on the second floor in the future so much power over our judiciary. And if you want an independent judiciary, if you want to maintain that, I would humbly ask for your red light. Thank you.
Is there further debate? Gentleman from 17.
Thank you, Mr. Speaker. The principal question I have is, what is the urgency? This has been in place for 50 years. Why is there such a major problem now that we're doing this in the last couple of days of the legislature? We have, at least in my case, I haven't heard from lawyers, clients, people, that there's any serious problem with the Judicial Council. I've never heard that. I haven't heard that. I've heard about all kinds of other problems, many of which we've been addressing, but I haven't heard of those of Judicial Council. In fact, I'm willing to bet that there's some members who've heard the name Idaho Judicial Council and probably nothing more about it. It's been fairly quiet, I think. And for that reason, I have to wonder what the urgency is, why we have to do this right now. Now, there is one exception, and I do occasionally hear somebody complain about a judge or complain that they didn't make the final four for consideration, but they're usually complaints. It's usually not the winner. It's usually somebody that didn't win their lawsuit or didn't succeed. But generally speaking, haven't heard these complaints. And that to me should be the basis of a vote on this bill. The important thing to remember about this bill even coming to the floor is that the Judiciary Committee made no recommendation, didn't recommend it pass. We didn't vote to hold it. There's no recommendation. And I think that's indicative of the fact that hasn't been a lot of discussion on this issue for everyone to formulate what their feelings are and what their viewpoint is. No recommendation to me means, Jesus, the committee couldn't make up their mind. Well, let's throw it to the floor and see if they can make up their mind. And I don't think that's the way we want to make super important decisions that are really impacting our government. So for that reason, I urge you to vote no. And I urge that we have a committee, maybe a legislative committee, interim committee, something, study this and come up with some recommendations. But let's think about this and think through this. I think there's plenty of time. There's no urgency. Thank you, Mr. Speaker.
Now from 16.
Thank you, Mr. Speaker. Would the good gentleman from 10 yield to a question? I guess the gentleman won't yield to a question.
There is another co-sponsor in the room.
Would the gentleman from 14 yield to a question?
Will the gentleman yield?
Mr. Speaker, I will yield, but it's time for lunch, so go ahead and make it quick.
Gentleman yields.
Mr. Speaker, good gentleman, we're aware that the Supreme Court is looking at forming an interim committee to look at the composition of the Judicial Council. Are you aware if those plans for that committee will be disbanded if we end up passing this bill?
I work from 14.
Mr. Speaker, good gentlemen, it's my understanding not, that they will meet and continue to try to resolve the issue. Remember, this bill doesn't go as far as I think it should go, and I think there's more things that need addressed. This is just a small step in the right direction. So it's my understanding that will continue to happen.
Mr. Speaker, to debate the bill.
You have the floor.
Thank you. First of all, I just want to start by saying that right now I'm going to be debating points, but I'm not going to be debating people in here. And I hope that you would respect me in the same way. As the good gentleman from 14 just mentioned, to my knowledge, to his knowledge, that the efforts of the Supreme Court to look at the Judicial Council, whatever the outcome is today, then this is a dialogue that will continue. And so if it passes, if it fails, we can still continue to have dialogue. We can continue to look at this in the coming year or years. Some of the concerns that I've heard have to do with if this is going to politicize the Judicial Council. We have discussed how the governor is going to be making 8 of the appointments to the Judicial Council. The check and the balance to that, though, is already in place and continues with the legislation. With the district judge and the magistrate judge, then the judiciary is going to be making those appointments, and those are going to be confirmed by the Senate. So you have the legislature as a check to the judiciary. And then you also have all 8 of those appointments that have been mentioned. That will be made by the governor, but will be checked by the Senate. That is an appropriate check and balance of that power. And furthermore, depending on the outcome of the election, the whole notion of politicization, this cuts both ways. We're making a policy decision, hopefully not based on a political outcome. The other point that I want to talk about, what we're doing right now, we are crafting policy with regard to judicial nominations. Idaho right now, what we have is a nominating council. Now, we could do what other states do. We could use a gubernatorial appointment and just cede that power to the governor in its entirety and let the governor make that decision. We also could go through a legislative appointment process where we would be the ones who make that decision. What I've heard here today is that we prefer the Judicial Council, the nominating council. So let's keep this and see if this is going to work. Continue to work and even make it better. Currently as well, we have nonpartisan election for judges. This seems to work for us. Now, if we want to, we can go to partisan elections and we can make that policy choice if we want to. Personally, and in agreement with the people of my district, I think we all like the fact that we don't know what our judges' political affiliations are generally. If you've been here long enough, you've probably met retired judges. And I know that every time I have met a retired judge and then learn of his or her political affiliation, I'm surprised. And I want to be surprised. I want to know that when a judge or justice is sitting on the bench, that they are not looking at the law or at the parties involved through their own biases, but truly through the eyes of justice. I don't see any boogeyman in the bill. The one other thing that I did want to mention is that this bill still maintains through the attorney appointments and the non-attorney appointments to the Judicial Council a requirement that if we that in knowing what their political affiliation is,
that there's still representation from the minority. So we have minority representation, there's a check and balance on the system. These are simply my debate points, and I'm not making anything personal to anyone here.
Is there further debate? Gentleman from 15.
Thank you, Mr. Speaker. Fortunately for the body, most of the points I wanted to make have already been made, so this will be short. You know, before the first question that we need to ask when we're faced with changing something, especially something that's been established and until today really hasn't come under any criticism for 55 years, is why? What problem are we trying to solve? So I would like to see the list of judges that have been admonished, have been censored, or impeached that have come out of the Judiciary Council. I don't think there have been any. Maybe there have been in 55 years. There is no problem that is being solved that is inherent to any logical metric to indicate there is one. And I hear that all the time in the Education Committee. What are the metrics to justify making a change? So when I hear the good gentleman from 10 talk about connecting dots, you know, if a future governor is able to appoint 73% of the membership of this council, that might give a clue as to what dots might be connected and what might actually be taking place in the dark of night. I urge you to vote.
Mr. Speaker.
Gentleman 22.
Thank you, Mr. Speaker. I object to that line of debate implying that the gentleman on the second floor was the one operating in the dark of night.
All right.
I was referring to how this change could change the balance of power.
We've thrown that term around, including in the opening, and so let's all be careful with it from this point on. It would seem to imply something less than transparent.
Well, I would just ask, is there anything in the bill that indicates what process the governor, any future governor will use to determine who they're going to appoint? I didn't see that in the bill, so.
Thank you. Is there further debate? Good gentleman from District 32.
Thank you, Mr. Speaker. I know this has been an interesting debate. I'll keep this short. The gentleman from 16 brought up a point that's been troubling me since we started the debate this morning, and that is, I think there are two distinct parts to this bill, and I think the way we select the judges is one part, and the salary of the judge is a total and separate part. The good lady from 24 made a compelling argument for me, as did the gentleman from 30. This has been one of the few debates in the 14 years I've been here that I think may have actually had compelling interest and has actually probably changed my mind today. Thank you, Mr. Speaker.
Is there further debate? Hearing none? Gentlemen, please stand and close the debate.
Thank you, Mr. Speaker. Appreciate the debate. None of you want to hear what I have to say, but I'm going to tell you a couple of things. Some of the comments, especially early on, talking about the political process, really worried me. The whole process is political. You've got lawyers and picking lawyers to be judges. Think about that. That's not political. And now we have people in here debating, that's okay, we don't want anybody else involved. Just let us do it on our own little thing. And then we hear this stuff, well look, hardly anybody runs against these incumbents. That's the problem, they're incumbents. The power of incumbency prevents people from wanting to step up and be counted because they hold their hands back. That's why some of you in this room don't even have primaries. It works, it has power and it has an effect. And that's why this bill addresses that and helps make it better. One last comment. Good lady from 19, I've always thought you were for more open government. I've always thought that you were for letting the people know what's going on, not doing things in dark, hidden rooms, not hiding information. This bill opens it up where people get to know what's being said about them. The public gets to hear what's being going on. Why would you ever be against that? It makes no sense to me. This bill, in my opinion, doesn't go far enough. If we want to make the process better, if we want to have better judges, then quit whining and vote for the bill. Thank you, Mr. Speaker.
I'd like to point out Mr. Moyle's been there for 20-some years. Mr. Becky has been there 20-some years. Mr. Guthrie's been in the legislature 20-some years, and Winter and others have been there. This thing, as far as resigning in the middle of an election year, for example, was used by Governor Little back in 2001. He was a lobbyist for the IACI. And the other person that comes to mind is Senator Groh. He also replaced a retired senator that resigned in the middle of an election year. And the big one is Senator Risch, U.S. Senator Risch. He was kicked out for 6 years. Suddenly there was a senator in his district that decided to resign, and Governor or Senator Risch, the guy that the electors kicked out, put him back into office, and then of course the rest is history. $109 million in net worth from political office of 43 years. Keep that in mind in this debate if you watch it. But the Republican Party, the conservatives in Idaho, have used this little trick of the incumbents, having a 6-month incumbency to get them elected. And the 3 names that I mentioned are in power right now.
It is closed, and that was...
I object.
Jury will disregard the gentleman's last statement. So, debate is closed. The question before us is, shall House Bill number 782 pass the House? The clerk will unlock the machine, and the members will record their votes. Are there members who wish to change their vote? Clerk will lock the machine and record and read the pairs. How about?
Moon votes nay. Scott votes aye. Manwaring votes aye. Horman votes nay. DeMordaunt votes aye. Green votes nay. Palmer votes aye. Giddings votes nay.
The vote count shows 44 in favor, 24 against, and 2 absent. House Bill number 782 has passed the House and will be transmitted to the Senate.